Good morning. My name is John Gentile. Here we have our critical assignment, legal issues in kinesiology. The CAP assignment, the YouTube link will be posted right there at the end and submitted onto the platform. I chose a personal training facility. The facility background that I have, reason why I chose this is because I am a personal trainer, strength and conditioning coach, but I also am a part owner of the facility that I currently work at. Myself and my partner understand the rigors of owning and operating about a 2,000 square foot facility that can lead to the pleasures of owning the facility and some of the chronic headaches that can come with that. Just all the way from legal aspects all the way to just facility maintenance, stuff like that. So we do make sure that all our trainers are certified. They carry proper liability insurance along with up-to-date CPR and AED. Their certifications have to be from an accredited association such as NASM, the NSCA, or the ACSM. We do accept some others, but those are some of the main certifications that we do accept. We also accept individuals that have a bachelor's degree in the related field. So if someone's a physical education major or actually a science major, we do accept those because they have put the schooling into that, but making sure that they do understand the aspects of personal training and the facility maintenance that goes along with that. This is a reason why I chose this facility background in this CAP assignment is because it's going to give me a better understanding of what could possibly go on if negligence occurs, if someone gets hurt to employment and labor laws. The personal training facility can be a very dangerous place if the equipment isn't spaced out properly, if the equipment isn't properly maintained or cleaned. Some cases that occurred in a PT facility that I found are situated below, and we're going to go into each one of those cases. All right, so moving on. The first case is Rossetti versus Nesty Enterprises. This is where the plaintiff sued the gym and the personal trainer for negligence, stating that the gym and the trainer failed to investigate the client's chronic heart risks before working out. The plaintiff suffered a heart attack in their first session. The defendant was deemed not at fault, and the evidence showed the trainer without intent to injure the client. Lastly, the gym was not imposed to any of the liability that the plaintiff went on against because the trainer was an independent contractor. So they made sure that the independent contractor, who was the trainer, had the proper credentials, had the proper liability insurance. So that's what that case went through. This kind of situation can happen in any training facility or against any trainer. If the client doesn't answer truthfully or provide information to the trainer, it can be difficult for the trainer to provide the service that they want. So making sure that these clients or potential clients answer these questions truthfully so we can give them the best service at hand. And I mean, there are no signs of heart attacks. Yes, people do have heart risk, heart disease. We can help inhibit and lower the risks of that, but you could be the healthiest person in the world and still suffer a heart attack. So our goal is to make sure that doesn't occur, but that heart attack can happen anywhere. So pointing the blame at a personal trainer just seemed like a scapegoat to me in that case. The next case we went on is Orlando versus FEI Hollywood Inc. Incorporated, 2005. The injured person was filing negligence for not providing maintenance, supervision, and training for equipment used by the patrons in the facility. Basically, someone fell and hurt themselves when another gym goer dropped a dumbbell on the floor and the weight rolled and injured the fellow individual. The gym was deemed not liable for the other patron's conduct, deeming there was no intent to injure. It was unexpected action by the patron for dropping the weight in close quarters. Exercising in general in a gym, especially a public Globo gym facility, not a private facility like mine, Poses a bunch of risks. Just people not paying attention, walking around, tripping over the bench, being on their phones, just looking down constantly. So they do inherit their own risk by entering that facility. No one's intent is to injure anybody in the facility as far as I'm aware. I mean, I can't say nobody's going to try to hurt anybody, but most of the time everyone's in there to get healthy, be fit, live a long, healthy lifestyle, and they're there to work out. They're not there to hurt anybody. So you do inherit that risk when you do sign that consent form within the gym. I mean, injuries do occur. So next case is Heron versus Suture. This case, the plaintiff's bringing suit on the gym and the owner, personal trainer, the management company, and the dietary supplement company. They suffered a stroke during their exercise session with the trainer. They were taking a supplement that they didn't look too much into for their health risks, so on and so forth. Everyone was deemed not liable for that, meaning that the plaintiff themselves had to handle no one can tell you to take anything. You inherit that risk on your own by taking a supplement, any sort of food, any sort of beverage. That's on you. No one's forcing you to do anything. My little statement here, supplements should always be researched before taking them. No matter if it's vitamins, minerals, or ergogenic aids, the only people that can tell you what to consume are registered dietitians. All other parties can only recommend. So just making sure that my staff, we're not registered dietitians. We only recommend food plans, nutritional plans, supplement guidelines, stuff like that. So, I mean, we just give them the basic knowledge from what we know and what we've studied. And what works for us might not work for others. So we do understand that there are current health risks that go along with the dieting, ingesting supplements. So supplements, you're just taking whole food away by adding in an aid. So making sure that those are properly planned and discovered through the day, and making sure it's the right protocol for that individual to be consuming. So just making sure that we're all aware of our surroundings when we do perform when we do give out ideas and recommendations for nutrition and supplements. The next case is Macris versus Scandinavian Health Spa. This individual suffered a severe neck issue, herniated disc within the operating the leg press. The personal trainer told the client that she was just too weak in the upper body and needed to strengthen. When the client went and got examined, the findings found 3 herniated cervical discs in her neck. The plaintiff was claiming that the trainer was negligent in her supervision, instruction, and training, which led to her injury. Overall, the court ruled in favor of the plaintiff, deeming the personal training was at fault at negligence. Main focus here is pay attention to detail. If somebody is telling you something is hurting, client, find a way for it not to hurt. Personal trainers can't diagnose injuries. We're not doctors. We're not medical professionals. We're health professionals. We can help you in certain ways. So referring the clients out to specialists, or to tell them to go see their primary care physicians and go from there. This is a situation where making sure that your liability insurance, all the consent forms are up to date, your certifications are up to date, so you can't have any backlash. Obviously, the defendant was deemed at fault for negligence, but it could be worse. So making sure that it could be worse for the facility. If that person is not properly credentialized, doesn't have the right insurance, they'll go after you. So that's a great case there. Next, we have risk management. The risk management of injury and prevention within a personal training studio or facility needs to be the primary focus for everyone who participates in the facility. When it comes to creating control of these scenarios, the trainer and facility need to develop a risk management plan. So proper procedures and protocols should be in place moving forward. Some risk management cases to go into. We have Johnson versus U-Bar LLC. This focuses the fitness equipment by the trainer of the facility where she went to sit down and fell on the ground, and she ended up suffering a cracked vertebrae. She went to sit down, the seat was too low, and she fell and hurt herself. So in a situation, overall, the court ruled in favor of the facility and the trainer, stating that there was nothing conspicuous about the waiver. So she's saying that she was just suing for liability and loss damage, stuff like that. A situation like this might not always be avoided, but one can re-educate the member to make sure that they fully understand the consent form that they're getting into. In most cases, court will always rule or dismiss in case with proper documentation or records, and just making sure that all protocols are up to date. So if the equipment is faltering, making sure that the trainers understand that the equipment is being properly used. Just making sure everyone feels comfortable within the facility. In my facility, it's one-on-one personal training, two-on-one personal training, so nobody's really operating at their own risk, but they do inherit that risk when they come in because they have signed that consent. So making sure they do feel comfortable within the facility when they perform movements. I make sure that I'm very vocal. If there's something that they don't feel comfortable doing, just be vocal about it. Speak up. We'll make it comfortable for you. Risk management. In a case, the treadmill facility where this lady, Ingram, hurt herself while using the treadmill. The plaintiff was suing the treadmill company for negligence for assumption of risk while using the treadmill and for product liability in regard to strict products. Both of these cases were dismissed due to lack of evidence. The lady fell off the treadmill for inadequate operation. She would hop off, the belt would continue to run, hop on and off running intervals. It's a way to work out, way to train, but that's not the proper use of the treadmill. So to prevent any sort of claims against product liability for the facility would be make sure that all products are on regular maintenance routine, that they're cleaned properly every day. Or the facility or the trainer, they need to make sure the members or the clients know how to work the equipment properly. So if you are in that kind of Globo gym, making sure that everyone has that rundown of how equipment is supposed to be used and operated. And lastly, if a piece of equipment is broken or there's a malfunction, make sure it's properly documented, and an out of service sign is put on that piece of equipment, just so nobody gets on it. And if it's broken, it needs to be documented. And then making sure that that piece of equipment is fixed in a timely manner and it's properly documented with time and date. Next case is going back to that Macris and Scandinavian health spa case that we were talking about, where the lady was performing that. This would be where standard of care and liability insurance would help take place. Like I mentioned before, prevention of this measure to make sure that the trainer's insurance is valid. For most facilities, they require the trainers to carry their own personal liability insurance for them to be an employee or independent contractor. Additional prevention measures are to make sure the trainer of the facility has their certifications up to date, especially a national or certification for a nationally accredited body having the professional certification status, current level of training and education up to date, and along with their CPR, AED, and possible first aid will help the trainer, facility, and others if a lawsuit was to happen against them. Employment laws. This is very important when it comes to hiring and firing, promotion. I mean, I'm a small facility right now, but if you're in that big facility, you want to make sure that everything is done to the books. Not like we don't do it to the books, but we need to make sure when we hire, fire, promote within, that there is proper protocols. Making sure there's no discrimination within any of the hiring practices. The hiring requirements for personal trainer is the same as any other job positions when it comes to meet all the discrimination and harassment regulations. In a case where the EEOC went after Lifetime Fitness in a discrimination case against a pregnant lady, the lady was hired to be a personal trainer. She went in to fill out all her paperwork, and the gym emailed her back after she mentioned that she was 35 weeks pregnant, and they stopped communicating with her. The manager uh, 2 weeks after the fact that she contacted them that her employment status would be placed on hold because they hired two others, and that they told her to go to another facility and get hired there. Um, and the conduct against this conduct violates the Title VII of the Civil Rights Act of 1964, as amended by the Pregnancy Discrimination Act, which prohibits discrimination on the basis of pregnancy, childbirth, or related medical issues. The individual ended up winning her case, $86,000 for failing to hire based on sex. The basis of the hiring process of credentials and qualifications rather than race. So making sure that these individuals are being hired because they're qualified for these positions, not because of how they look, the color of their skin, their nationality, the gender, so on and so forth. So putting all that aside, making sure that qualifications come first, credentials come first, education comes first, that they're properly equipped to perform this job. More employment. Racial discrimination can happen anytime with the status of an individual's job. In the case between Braxton and Lifetime Fitness, describes the plaintiff was racially discriminated against when he was terminated. So making sure that the plaintiff filed a charge with the EOC claiming that he was terminated because of his race and in retaliation for complaining of discrimination. In January of 2011, the EOC issued a right to sue letter to the Lifetime Fitness Inc. Basically, to prevent any actions that could bring up discrimination. It's such a hard topic because everybody and anybody could say it was discrimination or why anybody gets promoted, hired, fired. You have to make sure that everything is properly documented when it comes to a termination, promotion, or hiring, especially if that board is so full of candidates. You want to make sure that you chose the right individual or the right individuals for that position, or even why you're getting rid of. Braxton ended up losing the case. There wasn't enough evidence, so it was thrown out. But they did have a lengthy court battle before it was thrown out for lack of evidence. Making sure that all individuals, the reason why they're released is valid. You just can't get rid of anybody because you don't like them. We get rid of people because they failed the code of conduct. They weren't performing their job correctly. You want to make sure everything's documented when you are terminating an individual, no matter if you're in the private sector or the public sector. The last employment issue that my facility could run into would be sexual harassment. I know we kind of mentioned that with pregnancy, but this is where a case where an employee at a gym was making sexual comments about staff members and actual members of the gym were labeled sexual harassment in the Rocona versus Best Fitness Corporation case. The plaintiff, Salvatore, brings this action pursuant to Title VII of the Civil Rights Act, alleging he was discriminated against on basis of his sex, which he's a male, by tolerating sexual harassment, created or tolerated a hostile working environment, and retaliated against him by complaining about discrimination when it terminated him for the position of fitness specialist in 2012. In this particular case, it shows that a hostile work environment was created, and the plaintiff took all the initial steps in going through the proper chain of commands before having to file a lawsuit. Within that case, it was dismissed because there wasn't proper evidence. The evidence wasn't there. There's another case where not all documents were well kept. he said, she said, he said kind of thing. So making sure that everything is documented, making sure sexual harassment policies and procedures exist and are updated to code. So having a plan in place can help correct or even prevent any sexual harassment behavior in the workplace. As an employer, all employees need to feel safe and welcome. So encouraging them to report any incident that happens to them or they witness is highly encouraged. Creating a healthy work environment will be the number one priority. Lastly, documenting all sexual harassment incidents will help eliminate any doubt when it comes to retention of the employee that is committing the harassment. The main focus is to make everyone feel safe and welcome in the workplace and eliminate any doubt of harassment. Sexual harassment, discrimination there's a zero tolerance. So making sure that all protocols are in place. So we have sexual harassment meetings, we have individual meetings, and just making sure that all parties are well equipped with the knowledge to make sure that situations like sexual harassment, discrimination, and any sort of civil rights act are not violated. The application and faith integration. What I would do with my facility is make sure we have all ethical hiring practices. So when we bring someone in, they're qualified for this position. Creating an employee handbook that all employees and staff members understand their roles and requirements of this position, and they sign it. It's all documented within their file. Making sure the facility is up to date with all safety measures and codes. So the ADA, OSHA, FLSA, the HIPAA, there's zero violations that we can have against our facility. All trainers and staff members are properly educated and credentialed. We're not going to bring anybody in just because they like to work out and they might look the part. You also have to be educated in the part. So knowing the systems, knowing how the body works. We're not going to bring anybody in that's going to cause any sort of liability to our facility without them being properly educated or credentialized. Making sure have a protocol in place if there is an incident that occurs within the facility. So if it's from minor to major. Someone gets a paper cut. Okay, make sure if they need any sort of service, a product from us. If they need a Band-Aid, okay, make sure it's documented. So in case an infection occurs, it doesn't lead to anything bigger. This was properly documented. We took care of it. If something down the road happens, we went through the proper protocols. Make sure. My staff would be employees of the company, not independent contractors. So monthly staff meetings and weekly meetings will be planned. So we're all on the same page. They don't need to be long meetings. Just as long as we are face to face, we understand what we're doing. Making sure if there's anything that's bothering them, that they want new ideas on how to make the process, how to make their work environment safer, more fun. Just knowing that it's the clients that really matter. I mean, employees matter, but the clients are the ones that are supporting their families and making sure that that's the case. Here are my Bible verses. First one, Proverbs 11:14, where there is no counsel, the people fall, but in the multitude of counselors there is safety. So making sure that people are on your side, that you are leading people correctly. If you're not showing face at work, if you're not being a good leader, people aren't going to follow. You want to guide, you want to build leaders within the facility. You want to be able to understand that everyone's there to work, but you need to guide them. You need to be sure that they're following your rules, your regulations, because they're part of your facility. They're part of your company. Next, Proverbs 28:4. Those who forsake the law praise the wicked, but such as keep the law contend with them. Make sure with rules and regulations, code of conduct within a facility, that everyone is following the rules. Even federal law, even state law. You can't can't break into somebody's house and expect to get away with it when you get caught. You can't racially discriminate when you're hiring someone for a job. Those are the laws. You can't, there's a law that says you can't go to the bathroom between 2 and 4. That's part of the law. No matter how small it is, you have to be able to work within the laws and praise what is at hand. Even though it might not be right, you might not increase that value, but you still have to follow the laws, the rules and regulations of the facility. Next, we have Proverbs 29:2. When the righteous thrive, the people rejoice. When the wicked rule, the people groan. Making sure that you create a fun work environment, that you are bringing in the qualified individuals, but they also are having fun doing it. You want to create a wonderful work environment for everybody, not just yourself. We're the ones that are operating the facility, but the people that we bring in, we're bringing in the right people that understand how we want our facility run. We don't want anybody who's in there who's going to cause any issues, problems, show up late for work. They call out all the time. They cancel on their clients. They steal. We don't want anything like that. We want individuals that are going to create a fun work environment for themselves, for others around them, and give the clients the service that we want them to give. I do think that there can be issues when using God's word to guide one's career. If the individual is endorsing or favoring or disproving any religion, you can't tell anybody how to think, how they want to be. It's like politics. You can't tell anybody who to vote for. I'm not going to go in there and tell anybody who they should preach to, but I'm not going to be the one preaching my values to somebody else if they don't want to hear it. I find that unethical, not right, and it could lead to some further incidents down the road with the facility. I personally believe my religious beliefs. I personally would leave my religious beliefs out of any discussion or promotion that would occur within the facility. I believe there is nothing wrong with practicing what you believe in, but there is a time and a place for that. I do encourage individuals to practice their beliefs as long as it does not interrupt the business at hand. So making sure the clients are comfortable with their trainer is a top priority. So if a client is not comfortable with how an individual is throwing their personal values, personal beliefs at them, that will not be tolerated. But if they both agree on the same stuff, I'm not going to tell them to stop. If they're getting along, I just don't. My number one priority would be make sure the clients and my staff are comfortable within their environment. Individuals can preach the First Amendment, but in my facility, rules are rules, as long as normal business operations are not hindered. The government put in place the freedom of speech, but there is a certain extent to that. There is always, you can say something, you could do something on the internet, but there's always a fine line of what will happen if this is said or this goes on. And we want to eliminate that what if. You can have your values and beliefs, but I really want everyone to make sure that the business is running properly without any hiccups when it comes to religion, when it comes to nationality, any sort of stuff like that. So running my business is a structure where instances are at a minimum are very important to me. Striving to make everyone happy is key, even if that means putting my personal beliefs aside. I'm not going to be pulling a coworker, a client into my office to preach my religious beliefs. I'll give them my values of where I see them going and my belief on what I can do for them, but I'm not going to preach God on them if they don't seem that that's the road that they need. I feel there's other ways of communicating beliefs and values than going just through the religious aspect of that. Um, so yes, I do feel that going back to the previous slide, there could be legal issues that could go on if individuals don't want that. And some of those legal issues go through the text of, like I mentioned here, disproving any religion or practice, coercion, faulting people into believing and participating in a religion if they don't feel comfortable doing that. Even if it is it could be a touchy subject, being my company would be privately owned and not publicly or government owned, but still got to pay taxes, so something could still occur. I do believe there are instances. All right, so there we have it. Here are my references, 2 pages of references. And thank you very much. So the personal training facility, we got the employment laws, risk management, and facility background. So thank you very much. Have a great day.